Amy White, this is Kirsty.
Hi.
And this is Amy. So I'm going to call the meeting to order. Do I have a motion that we approve the agenda?
I'll make a motion to approve the special agenda, the special meeting of the Board of Trustees.
Okay, do I have a second? And in favor, Kirsty?
Aye.
Michael? Me, aye.
Hi.
You can move over here if you'd like, just change it up. I mean, it's kind of silly that we're sitting this far apart.
Okay.
I don't know, have you bitten anybody away?
But I'm not.
I know, is that open meeting not problem?
I don't
Okay.
want people to think I'm too.
Yeah, don't think that we don't like you.
I'm good.
Move on down.
Assigned seats are not part of every meeting.
So, I'm gonna give it over to you, Amy.
All right.
But before I do, I just wanna say, I have gone to almost all of our ISBA workshops. She's wonderful, she covers a lot, and, yeah, I can't say enough. So,
Well, thank you very much.
I think we'll learn a lot tonight, so thank you.
You're welcome. Well, I'm sorry for the delay, first of all, from our original schedule. It has something to do with this, but I have yet to bedazzle. I also likewise apologize for the fact that this is not the prettiest of PowerPoint presentations, and it may have a typo or two. One-handed. But what we're going to talk about tonight is open meeting law. Feel free to interrupt me, feel free to ask me questions. It's probably the most common thing I have boards ask about, and probably one of the most common things we've dealt with. It doesn't change much. I've done this over 30 years now. Oh, God. And in the last probably 10 years, it's changed more than anything else, as far as the prior 20 from that. And we are even going to talk about some statutory changes that go into effect on July 1st. So with that, before we go into open meeting, I always like to start with this. And every district has a version of this policy. This happens to be your version. And having talked to your superintendent, I do understand that you are in the middle of a policy rewrite. It's always fun. I'm in charge of policies where I work regularly, and I spend all afternoon on non-discrimination policies. So it is a task, and it's really hard to keep up to date because it constantly changes. But this is one that always stays constant, and it's about the authority of a board member. This is your specific language. That you only have authority when you're sitting together as a group. If you are not in that capacity, you have no greater authority than a person on the street, any of your constituents, any parent, any resident. I would actually argue you have less authority than a person out on the street, because there are certain things as a board member you can't do that a member of the public can do, because you have to remain unbiased and neutral to handle anything for which somebody has a property right under the Constitution. So a student hearing or a personnel matter. You can't go out there and voice your opinions, because your opinions will prevent you from ever sitting as a board member on those types of things. So that's why I say you actually have less authority and less ability to address matters of the school district as an individual than your next door neighbor does. So you only have authority when you sit here as a board. You have no separate powers just because you happen to be a board member. There are the exceptions of if the board has authorized, sometimes they'll authorize somebody to be a spokesperson if you do not have a communications person. Oftentimes the chairman has to sign all sorts of things that's authorized and addressed. But otherwise, everything that you do as a board has to take place in an official meeting and as a group, as a quorum. So I always start there. And this is the other one I'll hit upon. These are your district policies that outline your roles and responsibilities as a board. So your powers and duties in 212, the duties of your officers in 214. Those are very much consistent with what is in Idaho Code. The Code of Ethics for trustees, that's pretty uniform around the state. Everybody pretty much uses the ISBA model because it's tried and tested over many, many years. It's had a few tiny tweaks in the past few years, but that's it. 222 directs conflicts of interest as a board member. Again, that is pulled out of statute. That's out of Idaho Code 33507. And agenda preparation is one that you guys do have. It is your policy 260 at the moment. I don't know if you're renumbering. But I also understand that you are in the middle of redoing this one, and it was one that I did point out to the superintendent, does have a few things in on it that, one, I didn't like, two, may create a problem, and she's like, those are the things you're looking at. One of them was delegations, that it's too late in the agenda. The other one that I did not like was the unscheduled matters. What the heck is that? You know, so I do understand you guys are in the middle of redoing that policy. So it's one of those things that will get cleaned up and corrected as you guys are doing your policy manuals. There's one other one that I pulled out as I was reading, and that was public participation. Again, you guys are in the process of working on that, and there's a new statute that goes into effect on July 1st. So we're going to talk a little bit about that new statute. But nothing in that new statute changes the fact that public participation in a regular or special board meeting, that is not a hearing, and we'll talk about the difference. It's not a question and answer period. It's just a period to obtain public input. So we will talk about that a little bit more in detail when we talk about the new statute.
Are we gonna talk, why did you think the delegations was too far down? I guess I just,
You'll understand that
Okay.
shortly too with the new statute.
thank you.
Yeah. So here's the general philosophy of open meetings. And it's the philosophy not just of school districts, but of all public entities. That the formulation of public policy is to occur in open. Everything is supposed to be transparent. The public is supposed to know what is going on. And you'll notice on the bottom here, I've identified the code section. It's 74201. 74 is a governmental code, chapter 74, or excuse me, title 74. Title 33 is the one that you as a school district will see the most often. That is the education code. But Title 74 covers multiple governmental entities. So it does state that the formulation of public policy is to occur at open meetings because the members of the public they haven't yielded their sovereignty. So they're supposed to hear and understand what is going on and the decisions that the public is making, and that the formulation of public policy is public business, so it shouldn't be secretive. Every governmental entity in the state of Idaho has to follow that general philosophy. There are three definitions that are important when we are addressing open meetings, and it's decisions, deliberation, and meeting. Again, you'll notice those are all in Title 74, so again, they are applicable to all governmental entities. What is a decision? A decision is any determination, action, vote, or final disposition upon a motion, proposal, or resolution, ordinance, measure, etc. Those are other governing bodies, which a governing body is required at a meeting which a quorum is present, but does not include ministerial or administrative actions necessary to actually carry out the function. So you as a board, when you make a motion, I hereby move that, that's a decision. If you are directing the superintendent to make an action, or a resolution, you're adopting a resolution, sometimes you'll have a formal resolution that you're adopting. All of that is by definition under open meetings law a decision. And a decision must occur in open session, with 3 exceptions for schools that we'll talk about. Deliberation. Deliberation is probably where the most open meeting violations occur. There is a definition. It's the receipt or exchange of information or opinion relating to a decision, but does not include informal or impromptu discussions of a general nature which do not specifically relate to a matter pending before the public agency or decision. So, what would be some examples of either of those? If you run into somebody at the grocery store and they start telling you about they like the football team, they dislike the football team, whatever, they like an English curriculum matter, that's not something that might be pending before you to make a decision. It's just a general discussion of an impromptu nature. That is not a deliberation. If somebody comes up to you in the grocery store and you start having a conversation about a matter that's on the agenda in your coming meeting, that's a deliberation. That's a receipt or exchange of information that qualifies. Or somebody telling your opinion about something that is coming to you as a board. Likewise, you doing the same. Yes?
So is that deliberation like an open meeting is really when there's a quorum, is that correct?
Quorum is present.
So if I'm just on my own, there's not a quorum present, and someone's talking to me, then the open meeting laws don't apply?
Them talking to you about it is not a violation of an open meeting law. What you do with that information, however, is important and could trigger. And we'll explain that as we go along. So somebody shares something with you. That sharing alone, unless there are these people sitting here next to you, is not a violation. A member of the public sharing is fine. Now a meeting is the convening of a governing body of the public agency to make a decision or to deliberate towards any decision regarding a matter. So those are our big three definitions. And they attach here. So, a governing body is required to have an open public meeting. So, except as provided below, which would be executive sessions, all meetings of a governing body, so all meetings, when you've got a convening of a governing body, when you've got a quorum present, they're ready to make a decision, shall be open to the public, and all persons permitted to attend, except otherwise permitted by the act, which is executive session. No decisions, we already talked about what a decision was, any determination, action, vote, final disposition upon a motion, proposal, resolution, etc. Shall be made by secret ballot, so that's going back to everything is supposed to be transparent unless it is in executive session. And let me just touch upon a few things in there. So this is what requires you to have this meeting that we're having today, sitting here in the open. It's been noticed, and we're having the discussion. Executive session does allow you to then go in and deliberate and discuss. In 3 situations, it allows you to make a decision away from the public and not open. Secret ballot. We have had districts who do paper voting. More often than not, it's in a hiring situation or when you're filling a board position because nobody wants to vote out loud. Well, they can't do it secretly. So everybody has to, your name has to be on it, who you voted for, what way you voted for, and those are public records. So you might as well just do the regular vote. When you do a paper ballot, it does tend to create questions and suspicion. And if you can't make it secret, you might as well just do it open in public anyway. Just a last thing, the governing body shall not hold a meeting in any place where discrimination on the basis of race, color, sex, religion, age, national origin is practiced. You also cannot hold a meeting in a location where someone who suffers from a disability cannot attend. That's actually a violation of federal law. This is a violation of state law. I actually had a trustee once who tried to hold a book study in their house and have board members and school personnel present. And you can imagine the school employees get this invitation and they think, I've got to go to this meeting. I can't turn back going to to a board member's house. The house was not handicap accessible, so that was my easy out in saying, sorry, we can't do this, instead of allowing for that meeting to take place. Here, level surface, 2 doors, anybody can get in and out. Troy knows from his West Ada experience and mine, their boardroom's on the 2nd floor. You have an elevator, you have to access up through that. So that is how we can address that. Now, in our tech era, all meetings can be conducted using telecommunication devices, which enable all members of the governing body to participate and communicate with each other. Bottom line, the public needs to be able to hear you, and you need to be able to hear them. Whether it's done by open phone line, Zoom, Teams, Blackboard, all sorts of different things. Obviously, during COVID, this became very popular. I also had a district years ago who had a board member who was a long-haul trucker. And he used to join the meeting back in the back part of his truck every meeting, and he never knew where he was going to be. But he was on Zoom, and he was at every single meeting. To do that, you have to have somebody physically present. And that person needs to typically be a member of the board or the director of the public agency or chief administrative officer. For a school district, it's either gonna be a board member or it's gonna be the superintendent. Why do you have to have that person there? That person has to be able to let people into the meeting so that it is still open to the public. Where we see these happen is if you have one person who's out of town or can't make it, laid up in bed, whatever, on vacation. Typically when we have one board member or the superintendent present, it's a one-subject, quickie, emergency special board meeting, go and get it done, get it over with, and it's taken care of. Post-COVID, I'm not sure of anybody who's really held a full board meeting in that methodology. It worked. It wasn't the tidiest of things, you know, you learn not to talk over people, but it works. Allowed to do it. Executive sessions. Those are sessions that are obviously closed to the public. It is the board's decision who to invite into that meeting, and in making that decision, the board has to consider what the subject matter is, and if the person they invite has the rights to be there. So, hypothetically, the board is conducting the superintendent's evaluation. The board is obviously going to be present, the superintendent's going to be present. It's up to the board as to whether or not the clerk is present, because sometimes that's pretty uncomfortable if the clerk happens to also work for the superintendent. Some districts have policies that require the superintendent to be present at all executive sessions except those which the board is separately and privately discussing the evaluation of the superintendent or the performance of the superintendent. But again, that's a board decision because the board enacted that policy. The board could undo that policy if they wanted. Typically, that's the majority of who is in. Occasionally, if you are hearing a grievance or you're hearing a student matter, the only people who are going to be in there are those who have a legitimate educational need to be there. So the grieving party, they may ask for their family to be there. That's their choice because they brought them in, so they disclose their confidentiality. But the board has to consider the confidentiality status and what is being done. And as I indicated, the board policy may exist that addresses attendees. That's more often than not the one that talks about the fact that the superintendent shall be present at all executive sessions. Typically, the clerk is also present for all executive sessions, and I'll just give a shout out, sorry. When they stop you from doing something in executive session, typically when I do a clerk's training, I tell them to stop you. If you're going astray on the topic, if you're going off topic for the purpose of the executive session, if you're going beyond what open meeting allows you to, they're going to try to get you back on track. It's part of their job. They're not being difficult. They're not trying to tell you what to do. They're trying to help keep you within your lane. And I always say, blame it on me. Amy told me to get you guys back on track because you don't want to violate open meeting law. You don't want to get fined. So that's typically one of the reasons they're in there. The other is to keep and maintain the records, keep track of when you go in and when you go out. Executive sessions themselves are very limited use, as outlined by Idaho Code, and it's, again, 74206. Again, that applies to every governmental entity. So there's a laundry list of executive session topics that we're going to talk about, not all of which apply to school districts, and not all of which would be applicable to another governmental entity. Judges look at that very narrowly. So if you're like pushing the edge of, well, is this really executive session or not, and it gets challenged, we're just as likely to lose that as we are to win it, because judges do read them very narrowly. To go into an executive session, you need a roll call vote and a recording in the minutes of that roll call vote. It needs a 2/3 vote to enter into executive session. So with a 5-member board, you need to have 4 votes to enter. There is an exception if there are missing board members, and by that, it doesn't mean that somebody's not there that night. It means that you have vacant seats. And we had to get that into Idaho Code because we had some problems where if you had 2 missing board members, it was really difficult. Now, typically for a vote, you do not have to do a roll call. And the other, there's 2 other oddities in there. The determination of the outcome of a vote is the majority of the votes cast. So if you have 5 members present and 2 abstain, 3 voted, 2 to 1. 2 votes in favor of something just passed something out of a 5-member board. Another oddity is that Idaho Code specifically provides in Idaho Code 33510 subsection, I'm going to say 3, that the chairman is allowed to vote. Robert's rule says the chairman doesn't vote. Idaho Code says the chairman does. And when you really think about it, why would you want to disenfranchise 20% of your population? I mean, just because you happen to be elected chair, that's really sort of unfair to the 20% of the constituents of the chair that they don't have a vote. So that is a unique, and I get asked that probably 3 or 4 times a year because everybody is so used to Robert's rules where the chair just runs the meeting and doesn't vote. Now, if the chair is going to make a motion, there's nothing in Idaho Code that prohibits that, but it's probably best practice for the chair to hand over the gavel, then make the motion, and then the gavel can work their way back to the chair. But that is not addressed in Idaho Code. That's just one of those funny little things that we have. Now, for executive session itself, the reason for executive session must be stated in the motion, in the agenda, and in the minutes, and you must stick to those when you're in executive session. So if you're going in to discuss the superintendent's evaluation, that's 74206 subsection 1B, that happens to be evaluations, personnel disciplining, student disciplining, it's the one that's the most common. You can't go then, if that's the reason you're going in, you can't then go start talking about property or start talking about other issues. You have to stick to that subject matter.
I was just gonna say, I think on our agendas, it's just said executive session and not said exactly why. Is that?
It does.
That's what you read, what we
Up
read,
above.
that big
Like-
long clause.
Yeah, it says the clause, but it's just like the
It
general clause.
doesn't give the detail, it gives the general clause.
Okay, so you don't have to say that it is for a student discipline
No,
or
you
something.
just state the
Okay,
clause.
yeah.
Now, when this rule went into effect 18 years ago, school districts were like, well, we're used to just going into executive session, and they would write personnel. I was like, sorry, that's not the right thing. It's the whole thing in 74206(1)B, that laundry list. A lot of school districts were just literally writing every single reason that you could go into executive session, and courts said, no, it has to be a good faith, legitimate expectation that that's what you're gonna talk about, and not a placeholder for every possible subsection of executive session. So I know it's awkward, I know it's ridiculous, in the agenda, in the motion, in the minutes. So this is what the example would be, and then we're gonna talk through some of these. So I hereby move the Board of Trustees proceeded to executive session pursuant to, or to discuss matters as allowed by, I put the wrong, that's the old code section, that tells you where my brain was. 74206, I'll correct that when I send it back to you. 74-206(1), and then you insert the subject, which allows an agency to conduct business in executive session for. Now let's talk about what it's for. A, to consider hiring a public officer, employee, staff member. Okay, you can't go in just to talk about general staffing. You can't go in and say, you know, we've got 12 teachers at the high school, money's tight, we only need 8. No. You have to be in there legitimately talking about the hiring of an employee, where you're talking about the respective qualities to be needed and necessary to fill the particular vacancy. The most common one we see this for is superintendent. So you guys do your interviews, and then you talk about the respective qualities in executive session. Not general staffing, not general personnel, only to hire where you're talking about their specific qualities. Now, if the superintendent is making a recommendation to hire teacher A, and the board's like, okay, but we've heard lots of good things and bad things about teacher A and teacher B, there could be a discussion in executive session between the board and the superintendent. Let's talk about these 2 employees, let's look at their respective qualities, let's fill that vacancy after we talk about those. Very limited one. B, like I said, is the most often, and I broke it down into 2 sections, to consider the evaluation, dismissal, or disciplining of, or to hear complaints or charges brought against a public officer, employee, staff member, or agent. So this is the code section where one, you're evaluating, as the board, you're evaluating the superintendent, that one. Dismissal or disciplining of. So if the board is putting a teacher on probation, it's under this. If the board is non-renewing or terminating a teacher, and you're gonna have that hearing, it's under that. If the board is non-renewing an administrative employee or a category 3 employee or a coach, this is where you're going to do that, and then you'll have the informal review can be under that. To hear complaints or charges brought against a public officer, employee, or staff member or agent. If a patron has a complaint about an employee and it works its way up through your grievance process to you, that's where you're going to hear about it, in executive session under that subsection. Who is all encompassed on that? Everybody. Everybody's either a public officer, employee, staff member, or an agent of the district. Interestingly, if you as a board have a complaint amongst each other, it covers it. So you hear complaints or charges brought against your public officers, you're also agents. So you two can fight it out in executive session. It's a whole lot better to do an executive session than out in the open. Trust me. Not good out in the open. You know, your public's already suspicious. But that one is a surprising one that fits in there. Same part, Part B is also to consider the evaluation, dismissal, or disciplining over your complaints or charges brought against a public school student. This is where you're going to do your student hearing, your expulsion hearing. So that covers that one. You also can conduct deliberations concerning acquiring an interest in real property, which is not owned by a public agency. So if you are going to purchase, okay, City of Meridian and West Ada just did a property sale, which has been all over the news and nobody knows why. It was 5 acres of property, nobody used. It was 4 million blocks or whatever. That was between governmental entities, so it couldn't be done in executive session. Acquiring, you can only talk about buying property in executive session. You can't talk about selling property, which is really kind of crazy because you think you want to get the best deal. You don't want the whole public to know what you're willing to sell it for. We tried to have that amended, the newspaper association created a stink at the legislature, so we haven't managed to get that changed. So that one occasionally, you'll see, you know, if you need to buy property to build a new building, a new school, and you're buying it from one of the farmers nearby, that you can talk about that in executive session.
So who talks about selling property?
You have to do it out in the open.
Right here.
Oh, we just do it in open meeting? Oh,
yeah.
okay, just not executive.
Or
session.
you hire or delegate it to somebody so that you don't have to have those discussions.
Because
But then we
if you're
vote on it, right?
Oh, yeah, absolutely. Even when you sell it, you're still gonna vote on
Okay.
it.
the problem is that if you want to sell property, you know, you want the best deal. And letting people know about it ahead of time sometimes does not lead to the best deal.
Yeah.
And so that's been kind of an issue that she was talking about, that they've tried to get.
Everybody comes
Right
in
away.
and gives you the appraised value,
Right.
because you can't sell it for less than the appraised value.
Right.
You can sell it for more, but if they're all in there, oh, we'll take the appraised value, you know, you're talking about it in the open. Everybody knows, all the developers know, okay, I know exactly what I'm gonna offer,
Yeah.
appraised value in $1. If they're smart, appraised value in a little bit more than $1. D is one of my favorite, to consider records exempt from disclosure as provided in Chapter 3, Title 9. This is records that are confidential or private. So, attorney communications to a school board, you can talk about that in executive session. Student records are exempt from disclosure. Personnel records are exempt from disclosure. Your school safety plan is exempt from disclosure. All of those things fall into that category that you can talk about in executive session. You'd be amazed at the number of things we can put in there. And oftentimes, if I'm doing a termination hearing before a board, I'm going to do a belts and suspenders. We're going into executive session under 1B because we're going to have a student hearing, and on 1D because you guys are going to be reviewing the personnel file and personnel records. So there's 2 reasons to go in, so if something happens that one falls apart, I've got another one to fall back on. E, to consider preliminary negotiations involving matters of trade or commerce in which the governing body is in competition with governing bodies from other states or nations. I never had an example for this until recently. U of I,
Mm.
buying the University of Phoenix.
Mhm.
And the court agreed, yes, that was appropriate in executive session. So if you and other governmental entities are in competition to buy something or in negotiations of matters of trade or commerce, yes, we can do that in executive session. F, to talk to legal counsel when you have action pending, so you are already being sued or there is a tort claim notice against you or an OCR complaint or Human Rights Commission, anything that's akin to litigation, or controversies not yet being litigated but likely imminently to. You had a really bad bus accident, 10 kids were killed. Yeah, you're gonna get sued. We're allowed to talk about it in executive session. There is the equal paragraph for discussions with your insurance company so that you can have those same discussions in that regard. To consider labor contract matters authorized under 74-206A. How did I get it right there? Not, okay, whatever. So you as a board are going to discuss, okay, what are we willing to offer? What can we afford? This was their proposals. What do you think? What do you want to counteract? All of those discussions regarding negotiations obviously can occur in closed session. Otherwise, what's the point of negotiating, because everybody's going to know. There is a separate subsection, the 74-206A, that does allow you to, it's a separate section that also allows you to talk about contract negotiations with your association in executive session.
Are we missing G and H?
Yeah, G&H doesn't apply to you, it's like.
Okay, good. If it doesn't apply to me, I don't even know it.
Parole board discussions, it's
Okay.
gonna be crazy.
Don't need to,
Remember, this is-
don't need to put it in my mind.
They would be far more interesting in executive session. Like I said, this applies to every single governmental entity, so I've just pulled out the ones that relate to school districts.
So for instance, on J, the labor contract,
Yes.
like what's a specific,
So you're negotiating with teachers right now.
just teachers and other direct employees, not like a company that we're contracting? Okay.
Yeah, because this subsection here talks straight out about negotiations with your teachers association by whatever organization or entity that might be. And teachers in school districts in Idaho were sort of cutting edge on negotiations because you were the first entity that was required to negotiate in open. They used to be done behind closed doors. Who's been at this long enough that knows it was amazing. You'd be behind closed doors and anybody would say anything and then everybody would go outside and say something entirely different. We'd be like, were you at the same meeting? So then you'd have dueling press releases and then you'd fight it out. So now that's out in the open. After school districts did it for about 5 years that way, it changed. Firefighters and police now have to do it out in the open too. So it's worked pretty well. And people are much better behaved. A lot less business managers cry. It's really changed sort of the tone. Now, second the motion, chairman calls for the question, you have the vote, you do the roll call vote. Now, 2/3 of the board members have to be present to get into executive session. It does not mean that 2/3 of the board members actually have to vote on it or be present for executive session. You just need that number to get into executive session. And then it just, again, majority of those votes cast is what controls. Where would you have a situation where you have 2/3 vote to get in but not participating? If a board member is biased. So a board member is related to the family for the expulsion hearing. You can make a motion to get an executive session. There's nothing biased about that, and then you step out, and we have less members actually conducting it. Somebody's out of town, we need another body on the phone, they'll call in, we'll get into executive session, or they'll leave and not participate. Okay, executive session voting. As I indicated earlier, there are 3 times when a school board can. A school board is the only Idaho governmental entity that can vote in executive session. So if you are in an open meeting training by the Attorney General's office, they won't tell you this, because they've got everybody else in the audience. They're up there. So if you are voting on probation for a Category 3 teacher, the board may vote in executive session to put that teacher on probation, You are not required to. It's optional to do it in executive session. If you do it in open session, you're not going to state the teacher's name, you're just going to put teacher A, whatever, B number, whatever. I do have some school districts who never mention the teacher's name through the entire process. So you will get a recommendation to put teacher X on probation. You don't know who it is. You just have the recommendation. You can't be biased if you don't know who it is. It's really kind of an interesting process. So then it's just teacher X, whether you're in executive session or an open session. Probation for a renewable contract teacher also isn't optional. So you're, quote, tenured, somebody who's been here 4 or more consecutive school years with the same school district, they go on probation, you may do that vote in executive session. Those were the only 2 for quite a period of time. And we went in and said, well, if we're worried about the confidentiality of a teacher going on probation, maybe we should be worried about the confidentiality of a student being expelled. So it took a few years, but yes, the expulsion of a student shall be done in executive session. We used to just be able to have the hearing in executive session under sub B, complaints or concerns about a student, and then you had to come out in open session and vote to expel the kid. Everybody knew who it was. Everybody knew who was there that night. But now you shall do it in executive session. So we are the only entity that gets away with that. Now, I did indicate we have some new legislation. Senate Bill 1361 amends Idaho Code 33510. This goes into effect July 1st. Now, I don't know how many of you were paying attention to what was going on last fall, into the spring, in a little school district up north. It sort of blew up. A lot of different things came from the legislature. Different legislators went and passed different things about that mess. The board couldn't function, the board couldn't operate. People were deliberately missing meetings. They'd show up in the 3rd meeting and then leave. They'd show up in the 3rd meeting and leave. So it became a mess. This is the only thing that got through. So they have added to Idaho Code 33510, this subsection 4 is a new one. So by July 1st, the board is required to adopt rules of order and procedure on how you're going to govern your regular meetings. Your rules. You get to decide what those are going to be, so long as they're consistent with the law. You are required to conduct your regular meetings in accordance with those rules. Again, just regular meetings. It's not talking about special or emergency meetings. You're required to make these rules of order and procedure available to the public at the regular meeting, so probably that table sitting right back there is going to have a copy of them on it, or you're going to have them posted on the wall. And you also have to have them posted on your website, how you're going to do things. And it's everything from what the order of your meeting is going to be like. I've had a few districts talk about voting. Okay, are we going to first, second, discuss, motion? Discuss first, second, motion? Motion, discuss, second. I mean, everybody does things differently. Those types of things you're going to have to make a decision on and come up with written rules. I haven't seen a final version of any of these yet. I know that April at ISBA, who writes a lot of the policies, sent me an email today. I wouldn't be stunned. It had a bunch of draft policies in it. I wouldn't be stunned if there's a draft in there. But you get to decide what those are going to be for you, so long as you're following open meeting laws, following confidentiality laws, and how you're going to do those things. Now,
So where does the superintendent fall into this?
well, the superintendent's probably going to tell you what they've seen from experience as far as what works.
Right,
What historically, if they know what the district has done.
okay,
I mean, ultimately, it's your meeting.
correct.
Ultimately, you get to decide that. They may give you a first draft and say, here, this is what's going around.
Or like ideas.
Yeah,
That
and talk it
inspire
through.
decisions.
Talk it through, have those discussions. Some districts, I have absolutely no doubt, will delegate to their superintendent, hey, write us a first draft of this. See what the other districts around us are doing. And I'm assuming most districts in a region will be somewhat similar. I expect North Idaho's to be different than Eastern Idaho's, to be different than ours.
Right,
Over here. So,
okay.
this is the changes that I wanted to come to about delegation. So whatever you're doing now isn't going to matter from July 1st because this is what you're going to have to do. So each board is to provide the opportunity for your residents, so members of the public residing in your school district. So not the traveling circus that goes around talking about the same issues all over the state. Been there, done that. Seen the same people show up at 5 different meetings. So your residents get the opportunity at regular meetings. You're required to hear public comment prior to taking action on an agenda item. So, let's stop there. We'll come into the next sentence. It can't be at the end of the meeting. It's gonna have to be at the beginning, because you've got action items all throughout your agenda. So you're gonna have to have that up at the beginning. Public comment is limited to items listed on the meeting agenda. So they can't come in and just talk about any subject under the sun. It has to be on an agendized item. I would even have in your sign-in sheet for people who want to talk, what agendized item do you want to talk about? I'm not going to ask you specifically what, just which item is it? That way you might be able to organize all of those, you know, when the clerk is collecting all those, well, this is all on the first item, this is all on the second item, those types of things. Nothing in this subsection restricts you from establishing reasonable standards for the comment period, including time limits and standards.
So if someone like emails and asks specifically, like, hey, I would like to talk about
Right, that's
this?
gonna come down here.
Okay.
This is still public comment. Yeah, you're on the right track here. You're gonna segue me into 7.
I was gonna ask, so if they go to sign up and let's say they wanna talk about curriculum and it's not on the agenda,
Nope.
they can't do it.
Not that night, not that meeting.
Okay,
Doesn't mean, if somebody wants to talk about that, oftentimes what I've seen districts do is, look, that's not on our agenda tonight. I'll direct you to the superintendent or the curriculum director, feel free to go speak to them, and then we'll come down to this part here.
But we can refer to this code or
Yeah, this
law.
is it. This is all the
this is
law.
the new code.
Yeah, this is what law requires us to do.
So
And it's a shall, it's not a may. So you don't have an option of taking other stuff.
Okay, so I know that Boise School District will take delegations, they can just, they write them in or they send them in, they're not there that night. And then they can look at to see if they wanna put those on the agenda or what they want to
She
do.
said that's
Oh,
7.
down there.
We've got that.
She hasn't gotten there yet.
I have had somebody ask me in the past week, we make somebody sign up for public comment 24 hours in advance. I'm like, okay, interesting rule. I could ask you why, but I'm not even gonna go there. You're allowed to amend your agenda, which is another section we're gonna talk about, up until that gavel claps.
But once we start the meeting, no more.
Once you start, but how is somebody, if you've changed the agenda 2 hours before your meeting, and you make somebody sign up 24 hours in advance, and you're gonna take action on the item, you can't because you limited public input. So you gotta, I'm like, that board, you really need to think that through.
So even
Why
if
is
it's
that
already-
rule so important? I would just let them sign up and do it.
So
Get it
even if it's
over.
already posted and it's already been, you can still change it up until the gavel, okay.
I was just gonna clarify the same thing as Kirsty.
Yeah, and we're gonna come to those sections on amendment.
Okay, because we
Now-
have been told in our district that we're not allowed to change the agenda once
Well,
it's
there's
posted.
certain issues that we will come through. Now,
Yeah, legislation too.
if I were to say, if I were to help a district write this, I would say, let them sign up that night. If they wanna sign up in advance, that's fine too. But if you're not letting them sign up that night, you are limiting what you as a board can decide. If you're amending the agenda. There's nothing in here that prevents you from taking written public comment, like you said, Boise. During COVID, we all started taking written public comment. With due respect to the people who stand up during a meeting and give public comment, written comment seems to be a much higher quality. Because people have the time to think through, they've written it out, they're also not nervous and shaking as they're reading it. But that could be one of your reasonable standards in your rules. Time limits, the 2 or 3 minute rule that everybody has. The non-repetitive rule. Don't start screaming at people rule. You get to establish those as far as what happens during public comment. And a lot of districts already have those. So this is brand new. You're gonna end up with a policy on this. What you're going to accept, how you're going to accept it. Again, it's regular meetings only. You are not required to take public comment at special meetings. That is at the board's discretion, just like it always has been. There was nothing in Idaho Code up till now that required public input in a regular board meeting. So this is entirely new. Now, this one was a struggle. Public comment relating to subject matters that authorize that are executive session issues are not permitted. So somebody can't come in and sign up on a Monday night or whatever night you have your board meeting, I want to talk about teacher X. Well, that discussion about teacher X is a complaint or concern under subpart B for executive session. They can't do that. They can't force the district into executive session. It may come down here, but it's not part of this public input part. So any of those subsections that we talked about for executive session, no member of the public can come talk about those. It's not permitted, and again, it's a shall.
So I have a question. Let's say somebody came in on a delegation and people on the board want to change the agenda, the gavel has not done. Can they just do it, or is it taken to a vote? Is it?
Well, the problem is, and we're going to come to that,
Okay.
changing it right there
Mm-hmm.
is a practical impossibility because you can't post.
Oh, because you can't post 48 hours.
And all the other, well, you can't post it all the places you're.
Right,
that you
supposed
post.
to in so much time.
Right.
Okay.
And so it's a practical problem. Now, this is the one that you were segueing me into. Members of the public, again, they must reside within your district boundaries, so not the traveling show, but your patrons, shall be permitted to request an item on the agenda. Again, must be a regular meeting item. Can't force you into executive session, just a regular agenda item. Once that request comes in, whether or not it becomes a part of your agenda, whether it's the next meeting, the meeting after, whenever, goes back to your rulemaking. Of you deciding what your rules of order and procedure are. So you decide in your rules whether you're going to do that. So most districts follow a practice that if two members of the board ask for something to be on the agenda, they notify the chair or the clerk, and it ends up either on that agenda, a future agenda, whatever. I'm envisioning that's what we're going to see. That a member of the public has raised an issue, they went on the agenda, you're going to notify the chair, hey, this has been out there, the chair can decide, rules will say, yeah, the chair can decide to put it on. Or the request will go out to the board as a whole, and if two of you respond back to the clerk, not a reply all, respond back to the clerk that it's okay, then it may end up on a future agenda item. That is what I'm envisioning will happen with this. But again, it's up to an individual district. An individual district could say, we're putting on every single matter. There are practical reasons why certain things don't end up on agendas for legal reasons. So there's going to be those catch-alls that give you time, that it's not necessarily going to be on the next meeting. It's not necessarily going to be permitting an executive session item. So if somebody wants to put on the agenda, I hate the math teacher, they can't force you to put that on. I'm not saying you can't decide to put it on, but they can't force you to do it.
Are you going to talk more about the agenda later, or
Yeah.
is this the proper time for questions?
You can ask me the question, I'll slide it in.
Well, I'm just not totally clear on it, so I guess if you're going to talk more, I'll just wait
We'll get to
here.
that, that's cool. Now, public meeting versus a public hearing. Right now, we're in a public meeting. Most board meetings are public meetings, which is a meeting of the board held in public. If it's not the public participating in the meeting, that's a public hearing. You'll see the breakdown there. So a meeting held in public, it's limited with regard to the public's participation. We just discussed what the public's participation is. It's these things right here as of July 1st.
So does a policy need to be created for the new legislation?
Yeah, probably a couple.
Okay.
The public input, public forum, nothing in code requires this. I now have to change that. Right now, nothing in code requires it.
Right.
Come July 1st, it will.
Okay.
You as the district decide what the format's going to be. Again, the public forum, two types of policy exist till July 1st. That's, the free-for-all on public forum versus the agendized, etc. Now, open meeting considerations and why the board does not engage. Back to public delegations. This did not change in the new statute. Delegations is not a time for discussion. It is not a question and answer period. It is a time for a member of the public to give you their opinion on a matter you're going to be voting on. It is in the public so you can all hear it, and you all know what they're going to say, so that it helps you make your decision based on the same set of operative facts. Why we don't get into a question and answer period or engage in a discussion is because it ends up sadly becoming an open meeting violation. You don't know, especially right now, it'll be a little bit better with the July statute, but you don't know what somebody's gonna come up and talk about. If you start engaging with them, all of a sudden you're deliberating and discussing a matter that is not on your agenda at that time of the meeting. So we just violated open meeting law because our public does not know we are going to talk about this subject matter at this time. That's the sole reason why we don't engage.
So if you genuinely have a question or you want more information, then would you put it on the next agenda?
You could put it on the next agenda, or if somebody has some questions, oftentimes the chairman will be like, thank you, I appreciate, the information you shared. I, would either direct the superintendent, whatever person at your district is most knowledgeable, get in touch with that person, you get in touch with them, we'll work our way through. If it can't resolve, it could end up back up on the agenda.
So if we're talking about an agenda item, let's just say curriculum again, and someone has talked about curriculum, and we get to that place in the agenda, can I as a chairman say, I would like to ask this person questions now?
This person being the member of the public or
Right.
the curriculum director?
No, member.
No, I would keep it in
Okay,
delegations.
that's what I want to know.
Yeah, because it hasn't happened very often, but one time there was like a genuine concern.
I've been to board meetings where it's literally a back and forth, it's like, what are you doing?
Yeah, no, it was
Every
nothing like that.
item, you're
but
engaging in a discussion with
Every
the
once in
public.
a blue moon, there's just like, oh, that's actual, like something we would
Right.
like more information about, so that's why I asked. what
And it's
would
one thing
be
if you're
the-
asking somebody here, one of your administrators,
Right.
clarify something, but if you start having a conversation with the members of the public, we're
Then-
more in this category than that
then the
category.
public needs-
So at the beginning of the meeting, you talked about someone coming up to me at the grocery store, and that would be a violation of,
It
of
could be a
open meeting
violation.
if I engage with them there
No,
outside
that's
of the
not a
meeting.
violation there.
Okay,
It could be a violation when
so
we
I can
talk right
talk to
now.
anybody about anything I want outside of the
No.
meeting?
No.
And I can't talk about it inside, so I'm just trying to figure out when I can talk about it.
I'll come back to that.
Because I can't at the grocery store,
No,
and I
you-
can't in the meeting,
You
so.
come in the grocery store, if they're just going to tell you some general thoughts, they can share. It's
Mhm.
what you do with that information and your ability to share your thoughts that are limited, and we'll come back to that, I promise.
So if you
Okay.
gave, if she gave an opinion back at the grocery store
You
about
could
what
be in
they-
trouble.
yeah, that would be
So
very
I
easy to
would,
do.
yeah, if you could show me where it says that,
We'll
because
come back
I'm
to that.
looking for that.
We'll come back to
Yeah.
that, I promise you. A public hearing is a different type of, you're gonna have a budget hearing coming up. That's the one you do every single year. It's the most common hearing. That is a sole, that is a meeting where the members of the public, yeah, they're coming up, they're talking to you, they're not held to your delegations. Does anybody really come to a budget hearing? The members of the public participate more, Idaho Code requires it. You should preferably have a policy driving the procedures. Same open meeting laws, except it's noticed as a public hearing and they have to be also noticed in the newspaper. Timelines. Budget hearing's the most common one. The second most common one is fee increase. So if you're gonna increase your fees by more than 5%, you are required to publish it and have a hearing. If you're increasing lunch fees by more than 5%, if you're increasing, I'm in the middle of a policy right now, increasing rental fees. Nobody touched the rental policy for years. It's like, oh my God, we're really renting for that? Some of those are gonna be very sizable increases.
So what's
So
a
that's
hearing?
Public hearing. The chairman opens it up, the administration does a presentation on the budget or on the fee request. Members of the public just work their way through and share with you their thoughts, their opinions, what they like, what they don't like. You as a board then deliberate and discuss it and make a decision on it.
But
I don't
that's
think we've ever
different
had
from
a public
board
hearing.
meeting.
like that.
It can be part of a
Yeah.
board meeting, oftentimes a hearing is part of a board meeting, but you open it up separately. So you call the meeting to order, We're gonna do the budget hearing, open up the budget hearing. Finance presents, anybody can come up and talk about it. It's not like they are constrained.
Okay,
Because
that's
it's not-
new to me, I
Yeah,
didn't, because we've done
We did
it.
change our rental agreement and we did not do a public hearing.
Did you increase it by more than 5%?
I-
We're increasing in the future by 4.99%.
When was it?
I don't know, over a year ago, I
Yeah.
think.
Well, over a year ago, you're safe now. It's legal now.
Nobody got us.
Now we know.
Nobody gotcha. Yeah,
Okay.
it happens. I'm gonna talk about open meeting considerations during the meeting and outside of the meeting. So, this is where we're gonna talk about some of your questions. So, during the meeting, part of the transparency of voting is everybody is supposed to be making a decision based upon the same operative facts. If you're making a decision based upon what your neighbor told you, and you're over here making a decision based upon what teacher X told you, and this person here is just making a decision based upon their own opinion, everybody's just randomly making a decision. When you are deliberating and discussing, you're supposed to be talking about, this is why I'm voting this way. So-and-so at the grocery store, by name, shared with me this. I am using that information as part of my decision. Now, if you're not using that information, you don't have to disclose it. But I tell so-and-so in the grocery store, hey, thanks, but you know, when they start talking to me, I'm like, whoa, stop, take a breath. If you start sharing with me and I use your information to make a decision, which is totally fine and appropriate, I very well may have to disclose this conversation. Some people are totally fine with that, some people totally freak out with that. No big deal. So that's how you make the decision based on the same operative facts. You've all heard the same people in public forum or delegations talk about things. You're talking about, okay, well, in my experience, this is who I talk to, these are the opinions I've heard, those types of things. That's where part of the transparency, part of the decision-making process is to occur. Where else we get in trouble is deviation from the agenda during the meeting. We're going to get even more trouble now that they're tightening up things on the agenda and the legislature's paying attention. So if you are engaging in discussions as a board, deliberating and discussing that definition that we talked about at a meeting, you deviated from the agenda. You haven't given your public notice of what you're talking about, which is a violation of the open meeting law. Just because something's on the agenda doesn't mean you have to talk about it. We put it on there thinking we may get to this, we're not going to get to this, the materials weren't available, that's fine. Same is true on a vote. You may have something written down as a possible vote, or vote, you don't have to, you can table it. So don't think that just because it's on the agenda you have to talk about it, you have to take action. And don't talk about things, and you certainly can't take action on things that aren't on the agenda. And again, anything that you're going to take action on has to be noted in the agenda as a voting item.
So, now with the new legislation where delegations can only speak about agenda
Agendized
items,
item.
which also we can't speak about anything that's not on the agenda already.
Correct. It
So you-
tightens the meeting.
So you technically could talk to it, someone else, you could respond to the delegation as long as it's about the agenda.
The problem is it's not on the agenda at the time. So we have an order of when we're going to talk about things. Please don't ever put the time on it. You know, that we're not going to talk about this at 7:05 and this at 7:09. We still have districts that occasionally do that, and it makes a mess. It's closer to being clean, I don't disagree, but you haven't indicated that the first thing in the meeting is you're going to talk about everything on the agenda. You're going to talk about things in a certain order and in a certain manner.
So if we list delegations
First,
about agenda items, future agenda items, like, I just don't see where it spells that out in the open meeting law manual, so if you could,
because you're talking about a matter at a time that is not listed on the agenda.
I mean, we don't put any times on there, right?
Order, you can use the
Right.
word order.
So like, we put delegations on there, so people know we're gonna be talking about agenda items
later.
with the delegation. So,
They still can get up and tell you what they think, but you're not gonna engage in a discussion. You are to deliberate with each other. You're not to deliberate with the public. And certainly not deliberating with the public in a meeting, because again, it's a meeting of the board held in the public. It is not a meeting that is intended for engagement with the public or a free-for-all, under the definition of what is a meeting.
So in other words, we're just here to listen, take in what they say, and use it to what we need to do to make decisions. But we do not confer back or forth,
No.
because that biases us in some
Well,
way
it's-
sometimes.
it's not about a bias, right?
It's not about a bias.
Because we're all hearing it at the same time.
Because things that are gonna be biased are going to, things that are gonna be an executive session anyway,
Okay,
for the most part, because they're gonna be personnel and student issues that relate to privacy
okay.
matters.
So since we're in the meeting, we can listen to it all
You can listen,
and then just make our decisions,
Make a
but there's no
and you're all
in-between.
hearing it at the same time.
Mhm.
So the only way that you could ever get around that, and I'm not suggesting we'd wanna do it, is to have a delegation section after every single
It'd be a nightmare. There is
Agenda.
another way around it.
item.
Yeah,
There are other ways around it. You could choose as a board to have a public forum on a matter. It would be a special meeting, not a regular meeting, where you as a board, okay, say there's a single item. We're gonna go from a 5-day school week to a 4-day school week, and we know it's a hot issue. So we have, typically the members of the board will sit and listen. They may ask a question, but it's a single subject matter that is typically run by somebody who can run a meeting that isn't gonna be Sue. You might have a little bit more freedom then because it's a single subject meeting.
does that become a hearing more than a meeting then?
Theoretically, yes.
Okay,
Yeah, under the definition of the two, yeah.
okay.
Hot topic items.
So what if like you want community input on something you're going to vote on? Is that still a violation of open meeting law or
No, I mean, they can still come in and give input.
outside input, like it has nothing to do with the board meeting, like someone giving an opinion or us gathering information? I mean, that's still.
You're gonna love my answer. Being a board member is not about doing homework. Yes, you're supposed to read things, yes, you're supposed to learn about education, but you're not supposed to go out and do your own research or your own study about especially personnel matters or student matters, because that will bias you. Now, you as a district say, let's go back to the 4 and 5 day thing. You can have the board can develop a survey that goes out to its community. That can go out through the school system. You can choose to do that publicly, you can choose to have another entity do that, you can have it go out confidential, so it's a monkey survey that nobody knows who responds. You can get input on different things like that. I'm just using the 4 or 5 day, but there are other things that you can do. Districts will do climate surveys that way, parent engagement surveys that way. There's all sorts of ways you can still collect input that doesn't necessarily involve delegations. And you're also, in all honesty, going to get a greater response. A lot of people don't want to come down, like I said, and stumble through reading out loud when they're all nervous. But it's a good way to engage and feel the communities. But it's typically those big hot, calendar, 4 or 5 days. We hate the transportation company, those types of things, the biggies.
I wasn't clear on what you said about being a board member isn't about doing outside research.
Yes. You as a board member, remember my first slide, you only have authority sitting here. You have 0 authority on your own. I have had multiple cases where a board member goes out and does homework. They will start investigating something. Typically it's an employee. That's bad. Or a student. You do not have the protection of being a board member when you do that. You are flying on your own. So number 1, you're biased, you can't participate. Number 2, you can be personally sued and personally liable without the district's insurance protection or coverage. And I've had courts rule that way. I've had a court send the board home to get their personal tax returns and financial statements because they were personally on the hook for doing their own homework.
Own homework about an employee or a
An employee.
student. But
It
like,
is stupid.
if you're talking about like whether a 4-day school week or a 5-day school week is a good decision to make, you can do research.
You can certainly,
About, like,
that's why I said, you're to be
Yeah.
informed about school issues.
yeah,
You are allowed to read and learn. But when you're voting on it, I would say, hey, look, I've done my homework, this is what I've read, these are the trends, I would share that when you're in your deliberation and discussion, so you're educating everybody about what you learn. I have had trustees hold what I will call a town hall for their own zone, where they will sit and listen. Not engage, but you'll sit and listen to subject matters that your community has of interest. I would recommend very structured ways of doing that, because it can become a free-for-all, and it can become a Zoom. ISBA has done them and organized them, they'll help board members do that. It's another good way to collect information, especially on something like that, the 4-day, 5-day, the change of calendars, those big hot buttons that really upset families. So that is another way. But it's when you are out as an individual collecting information on something that's gonna hit an individual,
Sure.
whether it's an employee, a student, that whole list of complaints against public officers, staff, agents, etc. That's when you can get in trouble.
sure.
So if you, like when you went to a football game and you're sitting there as a parent, you don't like what the coach did, you do not put that on social media, in other words. I do not like
Would
that.
hope not.
Okay, but I'm just wondering, as a board member, we
As a
cannot.
board member, if you do that,
Yeah.
you will not be participating in any decisions relating to that coach.
Okay,
As an individual, you put that on as an individual. So you're not speaking on behalf of the board, you're again flying solo. So just like any member of the public, I could be subject to slander, defamation,
so be
harassment,
careful
internet
what you
harassment,
say
all-
and do,
yes.
yeah. Okay.
And as a board member, rest assured that is watched.
Of course.
Yeah. And if you are going to take personnel action, I may hear about it from a judge beforehand. So say you're gonna do a termination hearing of a teacher, and you've been on social media talking about a teacher. The union's attorney will go to court and have you declared disqualified for being biased, and here's all the reasons, and they start flashing all of these. I've had it happen before, it'll happen again. It's not pretty. But those social media engagements are also deliberation and discussion, the gathering of opinion, it's all out there.
But it's not a quorum, so it's not a
No.
violation on its own.
No, it's on its own face, it is not a violation, just like you talking to somebody in the grocery store, it's not on its face.
Mhm.
Well, no,
It's
but
what
someone-
you do with it.
Someone is allowed to give their opinion. I mean, you don't have to like go into a full conversation.
Absolutely.
I mean, but someone could sit
Thank
here
you
and
for
say,
sharing
hey,
your
this
opinion
is,
with me.
yeah.
And I've seen even boards that will come up with just a pat response. So that way you're not accused of, well, this is what you really said. Nope, we have a standard response and this is what it is, and I'll read it to
Yeah.
you. Thank you for, if you feel strongly about this, please feel free to speak to the superintendent. Or now under that new statute in July, hey, you can ask for it to be put on and direct them through that process. Now the agenda itself, your new process will define what your agenda is going to look like, what you're going to put on it, what the board considers to be appropriate for consent or non-consent, those types of things. But amending, because this was your question, about that. A regular agenda must be posted 48 hours in advance and a special meeting agenda 24 hours in advance. So for a regular meeting, if it's less than 48 hours but before the gavel, or a special less than 24 and before the gavel, if you want to change the agenda, because your agenda that's posted is your posted agenda. So somebody forgot something, all of a sudden something came in. You post a proposed amended agenda next to it, and in some manner highlight what has changed. Either you struck out what you're removing, if you're removing something, don't bother, because remember, you can table. You don't have to address it. But put the new thing on it. And you have to post it, and you have to post it at all the places that you at your annual meeting say you're going to post. It has to be at least on the district office location, it's on your website or some social media page. Please put it on your website, it's easier to find than the social media page. But we have districts who we post at every building. Okay, so it is effective at the last location it is posted. So I always use Blaine County as an example. They've got one of those remote schools out in the middle of nowhere. They used to have it, but they posted it every building. So you may post at building 1 at 50 hours from the meeting, but by the time it got out to the Cary school, it was like 46 hours. So you have to make sure that you are posting at that 48 and that 24, and you better be able to prove when it was posted. There is something that's called a clerk's certificate of posting where they certify what time and where they posted. Now, he can pull up the metadata and tell me when we posted it, thankfully. It is not effective until the motion to amend is passed. That's why you post both of them. Because if you only post the new one and the motion fails, you don't have an agenda. So that's why you keep them both up there. I've had the motion fail. People do strange things, what can I say? Just because it's on the agenda doesn't mean you have to talk about it. So it is not effective until the motion to amend, to approve the proposed amended agenda passes. During the meeting, it's near impossible. You need to state a good faith reason that the item was not included on the original agenda to amend during a meeting. Oops, I forgot is not a good faith reason. Basically, you need to be able to explain to me why it can't wait 24 hours for a special meeting for it to be a good faith reason. That's what a judge is going to ask. They couldn't have waited 24 hours. It was that important. Okay, the dam has broken, the water is coming. That one we can get away with. The building is burning. Okay, I'm going to move on. But actually nothing is upheld. Final action. So you can amend after the start of the meeting, if you can really come up with this, good luck. But you cannot amend for any action item after the start of the meeting unless an emergency is declared necessitating the action, and the declaration must state the justification in the motion and in the minutes. I move to amend the agenda to add an action item that we're canceling school for tomorrow because the elementary school is burning down as we speak. That one is going to hold. About it. This one you can amend, like I said, and I say before the gavel hits, but as a practical matter, it really isn't as the gavel hits because you still have to be able to post. It doesn't have to be the 48 or 24. You can post an hour before the meeting. You can't post 2 minutes before the meeting starts at all the places you said and get it on your website and you'll miss something. So realistically, there is a time frame that you have to do. In the old days, we used to amend agendas in the middle of meetings, it'd be action items, you throw on 12 different things in the meeting. That's not transparent to the public. That's also the argument if you're amending literally regularly. If you're amending every single meeting an hour before the meeting starts, and we end up in court, it doesn't look good because you haven't really made a good faith effort to amend. So when they say we really can't amend, you can amend, but it has to be at a reasonable time that we can get out there, posted on social media.
Right, like a day and a half before would be fine.
That'd be fine.
Yeah.
Now,
The day of, even that morning would be fine.
can be fine depending upon where you have decided things are posted.
Right.
If it's out at the Cary school, it could be a problem because somebody may have to drive out there.
We're pretty close.
We had schools that have posted at post offices. Is it open? Or they'll post at various city libraries. Well, is it open on Sunday? Can I get it out there? You know, things like that. It does create a little bit of a problem. But from a practical standpoint, you still need a little bit of time.
So for instance, we had this work session meeting with you previously scheduled.
Yeah.
And we weren't able to make that happen. We had previously stated that it was about an open meeting law from you. But if we knew we were gonna be able to that we needed to cancel it and we wanted to change the topic of that work session 24 hours in advance.
24 hours because it was a special meeting.
We could have changed the topic and talked about something else if we wanted.
So long as you had enough time to get
Right,
it
to
posted.
Posted.
Yeah.
And then you could still get the quorum,
Right.
absolutely.
Okay. Okay.
Now, reality, this does not work for a hearing, because a hearing requires publication in the newspaper at a certain period of time. So it's only really going to work for your typical board meeting issues. Now, more during the meeting. Okay, these are just practical things I've had to defend. This thing. Yeah, put it away. Don't use it during a meeting. Because then I have to fight when somebody does a public records request for, what were you texting and emailing during a board meeting? Just hand me your phone. Yeah, you don't want your personal stuff out there. So put it away. I have had a board member say, look, I have my phone out because so-and-so's in the hospital. If it rings, I will get up and answer it, and then they turn it upside down and push it away. If you're texting, if you're emailing, everybody assumes you're communicating with somebody in the audience, and you're obtaining information about a subject matter that you guys are talking about. Don't do it, because anybody can come in and ask for those records. You are still conducting the public's business. You're probably using the school's internet. You're on I'm gonna have a hard time not having to produce it. My favorite records production request ever, I shared this, the stupid things people do on school's internet. Somebody hooked up their school email address to their dating website.
Oh, gosh.
Fabulous reading. And somebody did a public records request for that employee's email. So
Oh, my gosh.
I had to read it all. You'd be surprised the stupid things people put in emails.
Do we not have a person?
But like
I enjoyed it immensely because I'm laughing like, oh my God, this stuff is so funny. And I can think, oh my God, this poor boy lives in a small community. He's never going to live this down.
Yeah.
So I had a public records request of my personal email and my school email by the previous board member that held my position. And but I didn't have any more than, I think I had one email that with regard to the school district on my personal email, so that's what I sent in. I don't have to send in all of my other personal emails, only anything to do with the school.
Anything to do with the school. What I recommend board members do is you're going to have a school email address. Say a member of the public emails you on your private, is there a friend, do they know you? Respond back on your school email address so that that communication moves. Text, it's the same thing. Those are always more fun because people are so much less formal than text. Try not to do school business on personal. Try not to intermix the two. Use the school email address.
But a public record,
If you're
like
doing the school's
anything to
business,
do with the school business, doesn't have to be the open meeting type thing, it's just any type of
Anything to do
communication
with the school's
about the
business.
school's business.
doesn't mean we're necessarily going to produce it, but it's still going to be a public record. I mean, there may be exceptions that allow us not to produce it.
Right.
Student matter,
So
personnel
if
matter.
someone texts me or calls me or emails me, what about a call? Like how, what do you do with
There's nothing
that?
to produce other than your cell phone records that you received a call.
Right.
So, yeah. That doesn't mean you can't get questioned on it. That doesn't mean
Sure.
somebody isn't recording you. That's always fine. Notes. Notes are public records that you're sitting here taking as well. They're often collected. Please don't write things on them that you don't want the public to see. Well, it may be really funny when you're sitting there when we're sitting in federal court and it's really stiff and it was funny and in the board meeting it's really not funny when we read it in federal court. And some nasty mean judge is looking down at you. So, don't write what a stupid question. What an idiot. Oh my God, I'm bored out of my mind. And these are just the things I've seen. Or if you do, please scratch it out heavily.
Amy, can I ask?
Gracious.
Yes.
So, notes that they've brought in on their own, are those also public record then?
Depending upon what it is, it potentially could be. I have a better chance of keeping those out of production than I do something that's happening in front of
So
them.
any of the stuff that they've written on these agendas then I just collect all of
Collect
that?
them, and then the question becomes, do you collect and keep? Do you collect and copy? You get to decide that, and those will board protocols that you guys are gonna come up with.
But we don't necessarily have to have them collected on every meeting, like we can decide whether, if it's just as, whether it's requested, like if there's a public records request for the notes.
There's something called spoliation in public records. It is, it's a criminal offense to
I don't
destroy
know what
public
that word
records.
means.
Spoliation,
Uh-huh.
you're basically destroying it, you're getting rid of it.
Oh, right.
I would have her collect it every meeting if possible, regularly, so that, one, you're not accused of destroying things, because you will be accused of destroying things. And like I said, it comes to your protocol, so say she's collecting it, well, you as a board can decide she's collecting the original, but you can have a copy. Now, what you do with that copy, where you retain that copy, is it confidential, especially if we're in one of these hearing processes? So say you take notes during a student hearing, and your board protocol is she keeps the original and gives you copies. If I was a board member, I don't want the copy of the student hearing notes, because everything in there is confidential. If it ends up getting out, we just violated federal law on that student's privacy.
No, we send out a newsletter, so I just take notes to remind myself what I want to put in.
And it's gonna be little jots.
Right. It's
And
not-
I'll be honest with you, 9 times out of 10, everybody reads your record, they have no clue what it's just, you know, one little word here and
So I
there.
can either
Reminding yourself to ask a question about this, you know.
but I can still keep my notes for to write in the newsletter.
Well, that's what I
Yeah,
said, if
she's
she
not so
collects the notes, then you guys can decide that a copy
If we
comes
can
back
make
to
a
you,
copy, which
absolutely.
I would assume we will decide that.
Right, and in reality,
Otherwise, I'm
it's,
not just taking,
I have no
I
problem
can't
with
remember
board members don't
everything.
take notes.
Oh, that's my newsletter. Not
Or you
really
can
good.
do, you know, just take notes that aid you in decision making. Like you said, if you're gonna do a newsletter, if you do a Facebook after, you know, or some social media after a meeting, you're gonna jot down like 4 or 5 words to remind you of something.
Or sentences.
Yeah, whatever, but you can come up with your protocol that she gets them, you get them,
So
you
do we
don't
have to
get a
write a
copy.
policy for that then?
That'll be in your
It'll be
protocol.
That'll be in the
Protocol.
protocol.
Yes. And it really is to protect you, because if the notes all disappear, we're in trouble. Especially if the hearing notes disappear and we get sued. So we terminate a teacher and they come back and sue us, well, you destroyed all the notes from the hearing. While the hearing was recorded, which we are required to have a court reporter or a recording, all the notes that the board took during the hearing are gone. It's a problem.
How long does the board secretary keep those notes then, just out of curiosity?
How long do you keep? It would be dependent
I don't
upon your
know.
records
Boxcar
instruction
is
policy.
filled with all kinds of things.
Is it?
so-
100 years?
Is it like taxes? I mean, I'm just curious.
Books up there.
7 years?
As
Yeah, how
a
long-
board,
Yeah.
you should have a records retention policy.
24 hours.
Just, well, the hearing, I'm gonna make you keep more than that. But you as a board have, what's your email retention policy? How long do you keep emails out here?
Longer than we want to.
Thank you. That's sometimes a problem though too. You should have a records retention policy, but that records retention policy also needs to have an out. For example,
Policy 277.
lots of school districts, where Troy came from,
Records retention policy?
they keep emails for 190 days, where you came from. Can you imagine what 5,000 people in emails collects in
Oh,
190
yeah.
days? You just can't. But there are certain documents that you have to be able to, as an administrator or employee, pull out of there and say.
That's okay.
So if you're notifying, say for example, a counselor's notifying a parent of a suicidal ideation, oops, document's gone in 190 days if you didn't pull it out. So you have to have a records retention policy, but you have to have exceptions to that. And they take a while to write and even harder to enforce and to train on. How long do you keep your handwritten notes when you do minutes? Do you have a
I
policy on that?
have, I don't know if there's a policy, I still have them though.
Brian is-
Some districts destroy the handwritten notes from the clerk upon approval of the minutes. Some don't, some keep them for a year, some keep them for 5 years. I mean, you get to make those decisions. Some districts record every board meeting, well, on YouTube, they're sort of out there in perpetuity, aren't they? Which takes care of the fact that if she destroyed the handwritten notes, because her handwritten notes too are public record. Draft meeting minutes are public record. So it's one of those you have to decide how long. Okay,
Just
sidebars.
I'm sorry, I
Yeah.
just have a question about email. I've been deleting like some emails from my,
That's okay. That's what we're here to talk about.
from my, but like, just
I like
like
the
so
honesty.
many school newsletters, after I've looked at them, they're like the ones that are going to everyone. I don't really have to
lose
hold
sleep
on to those in my email box, right? Cause our, you know,
He still
are you
has
deleting
those.
yours?
I don't delete anything. I let Jason have it on the server all the time.
I just, to keep it clear, I have to
All of
delete.
those are still on
Can you
the
get my
server.
deleted
It's,
stuff?
yes,
Okay.
if you delete it, we still retain it
Yeah.
for 3 years currently.
Oh,
We are,
great, I
that's,
can delete
my
whatever
question
I want.
is, like, we were working through updating that policy for data retention retention records, what, anyway, is it through third, is it done? Is that one done, or, okay?
I mean, we have a couple, like the record retention 277 was
Yeah.
in 2019.
So we were
prior to
updating
us.
that one, right?
Not 277.
And I'll be honest, records are a
We can't
nightmare for
appoint
every
it.
school district.
It's from
Um,
2019,
General
so
counsel
we
for
would have
Boise
to
and I were
start on it.
texting back and forth today because we both have the same problem that nobody's ever gotten rid of a student file. So we have hundreds of thousands of student paper files everywhere. Boise's contacted me, they got the same problem. What do we do with all this stuff?
Wait, but I can delete newsletters, right?
He still has them.
We can delete whatever
You
we
can
want
delete them
because
if you
Jason
want.
It's
has
easy.
them.
Jason's
Deleting
got it,
them,
yeah.
because I don't want
And if it
my,
is on your school server and you get a, or on your school
I'm
email,
getting off.
and we get a public records request for your email,
Wi-Fi.
I'm not coming to you to ask for it. I'm going to him.
okay.
I will come to you and ask you, is there anything on your cell phone, on your private text, or your private email?
No,
But school, I will go to him and say, just give it to me.
I do everything for my school email. But I don't keep that stuff because I am a parent, so I already get the stuff.
Exactly. Oh,
So
you're
I
getting
don't-
double whammy.
I don't need it everywhere, and I like my emails to be cleaned up and important. I wanna see all my important stuff.
And it's
No,
I
already,
guess
yeah,
I've
there's
worked
so
for the
much
school so
already.
long, I just let,
That's what I do.
Never know.
Do you have a different email address as a board member than from as a parent?
Okay.
Yeah.
Of
But-
course.
Oh, I
He's
think
who I
I
would
might
go for.
archive
I wouldn't come to
everything,
ask you
like
for your.
newsletters I'm
And use those
deleting, like
protocols, is that
other
262 the
communications
board
I
meeting?
archive.
That's probably what protocols are.
Is that
That
about
would
right?
be, I would
In your
suggest
policy,
to do.
when you did
That's
that.
It's
what I
probably
would
where it
suggest.
went off, yeah.
The board.
If you don't want it, like,
Yeah.
just. delete
Okay,
it, but-
sidebars, don't have them.
thank you.
Just don't have them. Okay, just don't. No, no.
Yeah, I know. I can't say, hey, Michael, how was your day today? I have to say it out loud to everybody, right?
Talk out loud.
Yeah.
Yeah, everybody assumes that you're doing what you should be doing, whether you're doing it
I'm
or
sorry, what
not.
are you talking about?
I mean, you could be talking about what you had for lunch today.
I
but to be
know.
honest, it looks bad. If you are actually deliberating and discussing something that should be on the open and loud, yeah, not good. This,
What if we're all talking amongst each other, like about something on the agenda in a meeting, because we're trying to figure out what the best decision is?
Just say it loud.
Dory
so
said it out
everyone
loud.
can hear it.
and you just say it out loud, you just talk
Oh,
about
no,
it.
yeah.
You don't whisper at each other, it's sort of like the secret ballot thing.
Yeah, so
Okay.
I'll just give you a example that just happened.
She's gonna throw herself under the bus.
I will throw myself under the bus, because you guys all know. One of our board members didn't understand what was being explained during the levy, and so I went and said, it's A, B, or D, A or D, B or D, and I didn't say it out loud, we were just talking here, and that was a sidebar that wasn't said out loud, and somebody picked up on it, so then that was like, could have been was an open meeting violation.
I'll be honest with you, I can go to a board meeting any given night at any public entity and I can find an open meeting violation, and that's including the ones I attend regularly, it's just reality. Your lay members trying to do the best you can do, these
Yeah.
things happen.
Well,
And it does say in good faith.
Exactly.
Well, and sometimes I just like to
I'm always
alleviate
thinking.
what's going on here, and so I'll try to say something funny, because, you know, it can be kind of tense.
Yeah.
And now I have to say it out loud, because
Say
it's
it out
funny.
loud, it can be funny, it can be out loud, and how many, do you have a lot of attendance?
No.
It depends,
Yeah, we
it
do, those
depends.
chairs are
Yeah.
full.
Yeah, it depends on what
the
we're,
issue.
yeah, depends on what's on the agenda.
Okay, you guys
That's how
are.
the school
We have the
goes, and then they all
faithful.
leave.
Okay, and just, we already talked about the new ones,
So I do
so
policy,
during the meeting, you
never
have to
mind.
make sure you follow the new ones as well. Now, outside of the meeting setting, just follow rule number 1 and you should be fine. Don't do outside the meeting what should be done in the meeting. So don't call each other and talk about what's on the agenda and how you're gonna vote.
But can we call one person and talk about something? Like if I want to talk to Kim about putting something on the
That's
agenda,
fine. You can talk to her about putting something on the agenda.
I think
would
it's
not
our
get deep in the
opinions.
weeds and say, this is why I wanted it, this is how I'm gonna vote, and this is why it's, just, I would like this on the agenda because whatever reason.
But like
Don't
what,
deliberate.
okay, so I'll just give a, like, it's a real live thing, situation. I would like to get a few different, like I told Kim that I'd like to get a few different options for how to hire a new superintendent. ISBA, maybe a couple of other options. And so I need to explain to her why I want that in order to put it on the agenda so that the rest of us can discuss it. Cause she's not gonna just put it on because I say to. That doesn't happen, I've tried that.
What?
Well, that one, I think that one's kind of self-explanatory, why I want to see what the different options are. I mean, it all depends upon how you say it and what you're saying.
No, she's not telling me what options she wants. That would be,
I'm just saying
Crossing
like,
I would like, yeah, exactly. I would like to put on the agenda a discussion regarding what are our options for resources in hiring a new superintendent.
who are the headhunters that we want to take?
What, do we want to do a headhunter, do we want to do, she'll get that, and that's fine.
but what
But
if I
but
wanna,
getting into the weeds of, I don't want this one, and I want this one.
Oh,
and
right.
Yeah, that's not, no.
but can she then put it on the agenda and I can come prepared to talk about
Absolutely.
that
Absolutely,
to the rest of the board?
yes. Absolutely.
And are you gonna do that?
Well, yeah, probably. So far, you just have one, right?
Two.
Two, so, yeah, we'll have to talk about that, but yeah. I don't have a
With the
problem.
process. Okay. Oh, whoops, down here, reply all. Line copy them all on the emails you send out because reply all doesn't work. Something all your teachers need to be taught to. You're not supposed to straw poll. So what does that mean? That means the superintendent or board chairman or the clerk shouldn't be calling you up and saying, how are you gonna vote on this? How are you gonna vote on this? How are you gonna vote on this? We already talked about public information shared. You know, you disclose with your decision making, so you're educating the public. No meeting before the meeting or after the meeting. What do I mean by that? It's just natural. You walk out together, you're in the parking lot talking. Everybody assumes you're talking about what happened at the meeting. You could not be talking about what happened, but it looks bad. And I've walked into those conversations, and sure enough, some of them are talking about what happened in the meeting. You're walking in together. Everybody assumes as you're talking about the meeting. No meeting or before or after the meeting, that also can include in public. Okay, we have, elementary school districts have 3 trustees. We have a elementary school district in the state of Idaho who had, all 3 trustees were family members. How do you go have Christmas dinner together? How do you, everybody assumes you're talking about school stuff. Don't sit next to each other at the football game or the basketball game. If you all go to the same church, please spread out amongst the pews. It's sad that I'm having to say this. I have had, a Lions Club breakfast where they were all serving. Put somebody in between you. I mean, it's not just the actual, it's the perception. And anytime you're having to fight off the perception, you've lost. Because everybody assumes you're violating it. Social media. Don't deliberate on social media. Don't engage in Messenger, because those are public records as well. So if you are on say you're on, we'll just pick on Facebook. You're on Facebook and you're getting input, or people are providing you comments about a subject matter that is on the agenda that night, and somebody does a public records request for all your communications regarding, it's going to include the social media, it's going to include the messenger. Don't tell people on social media how you're going to vote on something, because then you haven't listened to the deliberations or engaged in discussion. You've just come in and prejudged the issue. Yeah, you can use it for information gathering, that's fine. Social media considerations in general. Oh man, they bite people in the behind, don't they? There is a theory that you are a public entity, and can you really block people on social media because you're preventing somebody from exercising their free speech rights? Yeah, think that one through.
If they're mean to me, I'm gonna block them. I'm just kidding, I don't
I know,
really
I get
do
it.
it.
I have had board members put on their social media, this is my personal social media, this is not a place for discussion about school matters. Even a school district has to make a decision about its social media. Is it an informational gathering site, or is it a responsive site? And, you know, once you've gone down one path, it's hard to switch and go down another, because when you start blocking people, it creates a problem. Daisy chain meetings. This is a theory that came out of California, of course. Board member 1 calls board member 2 and they are deliberating. Board member 2 calls board member 3 and they're deliberating. Congratulations, that is considered an open meeting violation.
Oh.
Because more than, you know, a quorum, who has deliberated on the same matter that is gonna be before the board. Kinda crazy, but yep.
So it's a quorum even though, like, say
It's-
Kim and I talk about it and then Kim talks to
Mike.
Michael
Yeah,
and
all
then
three of
Michael
you
talks
just
to.
have violated open meeting law.
But I
Yeah,
didn't
then
talk to
calls
Michael.
Chrissy, yes.
Yeah, but
And you're deliberating.
But we're talking about the same thing. but
Yep.
between
you're
the-
talking about stuff that you should be talking about here
Don't
And you're probably telling him what I said.
Outside of
Yeah.
the board meeting, what should be done in the board
in
meeting.
the board meeting.
Now,
But
like
don't
you
you
said,
need
you
to
can
take
call
more
her.
time in the board meeting to deliberate?
You should do it in public, yeah.
You gotta deliberate in public, like if we're just all hearing stuff and then voting and having no deliberations, then that's not.
It's sometimes, like if you're on the third reading of a policy and nothing has changed,
Right.
okay, there's nothing to deliberate.
Yeah.
If it's the consent agenda and it's normal, there's really nothing on there to discuss, yeah, you're all gonna vote.
Yeah.
There are occasions where where it's so obvious
That we're all
that
gonna
nobody
vote
has
yes.
to, yeah. Or vote no.
Or vote no, yeah.
But normally there should be some,
Discussion.
yeah, some level
I
of
think we did
discussion. Yeah. Okay, if you violate it, if you participate in a violation, it's a $250 fine. If you knowingly do it, it's $1,500. If you do it more than once within 12 months, it's $2,500. That is personally paid by the board member. The school district is not allowed to pay for that under Idaho law. Now, reality, what happens? I get a phone call from Jan Bennett's office. Please fix this now. I don't want to fine them. We fix it. I'm real good at writing a motion to cure what is perceived to be an open meeting violation. There was or not, I don't know. I'm not necessarily going to admit it was unless it was black and white, obvious. But it's easy to clean them up. We have standard motions, it's become so easy. Okay, so any person who's affected by it may bring a civil action in the magistrate court to seek compliance. No private action will result in civil penalty. That's the prosecutor applying that civil penalty to you for violating it. The private action could be damages against the school district or the individual. It must be declared null and void within 30 days of the decision. That is what code says. The way case law handles this is if nobody has contested an action within those 30 days, or suit hasn't commenced within 180 days, you're fine, even if you violated it. So we did not have a hearing to increase fees by 5% or more a year ago. Nobody challenged it, nobody filed suit, nobody can at this point in time. It's over. It's done. The knowing violation can also be a misdemeanor. Nobody looks good in orange, okay? It's my favorite color, but it's not a good color.
Especially for a board member.
It doesn't go over well. Now, yes, we cure them. So a board can self-recognize a violation and cure it. Yes, it has to be properly noticed on an agenda. Or the clerk can get notice of an alleged violation from a member of the public. Board has 14 days to respond publicly, so you hold a special meeting. If you happen to have a regular one within 14 days, that's fine too. You either state an intent to cure or you ignore it, in which you say, I didn't do anything wrong. We normally address them. What normally happens? People don't do this. They call the prosecuting attorney's office and then we have to deal with it. And the prosecuting attorney hates it, so they don't make the people do this. It was a great tactic during COVID. Every single board member, just constant open meeting violation allegations. And I was on the phone with the prosecuting attorney tomorrow, and then I took one to me. So what happens? You notice on the agenda, potential declaration of open meeting violation as an action item. Then the next item is reconsideration of whatever that subject matter was for discussion and deliberation, and then you are gonna have a potential action item to take action again. So, and that is only to cure a violation that involves a motion or an action. If you guys are talking about something that no vote got taken on, all you have to do is declare, we violated, shame on us, we'll get training, won't happen again, thank you, goodbye. If you say voted on something, we have to declare it, undo the vote, and then do it right. Then we notice it properly, we deliberate, we discuss, it's gonna be the same vote, we all know it is, it's all form over substance. I hope that wasn't recorded, but well, if it was, it was. Anybody who wants to sue you during that 180, it's stayed. So they can't sue you while you're curing the oopsie that we made a mistake. Like I said, this has gotten to the point where we have standard motions. We have standard agendas, it happens all the time. Good faith, we're lay people, we're trying our best.
And so when we just barely had, is the violation against the whole board or one board member?
Depends upon what
The
happens.
situation.
And so
Yeah.
if the violation is about one board member, do we have to put it on the agenda that, like all this stuff that, or?
Well,
'Cause I-
let's put it this way, if it's one board member, there clearly wasn't a vote in violation.
Right.
So all.
But like the example of like the sidebar,
Yeah, that we would just say, hey, open meeting, we engaged in a violation through a sidebar, especially if you were talking about school stuff versus not.
and so that has to be on an agenda to
Yeah.
acknowledge that, did we do that?
Nobody's contested it within 30 days.
No,
No,
We didn't need to.
we didn't need to.
I thought we were
It was
supposed to.
investigated.
it was investigated and found that it was okay.
Because
Oh.
you have,
So it's
Wait,
an
back
alleged
up.
violation,
Yep.
right?
because you have, whoops, where did it go?
I'm a rule follower, so it was like,
You have 14 days
found out that it was okay.
to either state an intent to cure or determine no violation has occurred. So yeah, you've got that 2-week time frame to decide, no, we looked at it, it was
Yeah.
fine.
So they're,
So
in
then it
this
doesn't
case,
have to be on the
that said
agenda.
no
The
violation that
inspector,
occurred.
the inspector, and she heard me talking, not about what I was explaining, so she was able to
Yeah.
say something to the investigator. And,
And
yeah,
really,
I was
we
just,
have- we
I was
have
just
a lot of
clarifying
things
what
to
we
do.
were doing. And so, but now on, I just clarify out loud.
There you
Just
go.
talk real loud.
So now,
I
any
know, let me
other
tell you,
questions,
A,
guys?
A, or B.
I went longer than I thought I would, but any other, that's because we engaged in.
I just had some questions, but I think
Ask
you
away.
covered them all. Let me see here. I think you covered all my questions that I had. Way to go, Amy. Do you guys have any other questions or anything?
And as of July 1, law
New law.
supersedes policy, and then we'll get our policies fixed based
Well,
on.
as of July 1, that statute comes into being. I would try to the extent you can to have something in place.
You assume we get second quarter policy updates here soon or that?
I've looked at the first couple April had, like I said, she sent me an email with more.
But we can start putting it
You
together.
can start putting it
before
together.
July. That
You
way.
can-
Right, right.
But we can go off kind of what we've been doing too.
Absolutely, that's where,
You know.
that,
And
the
then we'll get
starting
our
point
Yeah.
for most districts is gonna be, what have we been doing?
What have we been
works,
doing?
what doesn't work,
And then
what
we-
fits in the statute, what doesn't, like delegations is gonna have to move up.
It's not like
Or you're not gonna
the
be able to
10
vote on anything
Commandments.
till the next meeting.
It's not set in stone. It can be a active thing that we're changing it as we go, right?
So what's like the time frame when there's like a new legislation, how much time do you have to address policy?
Everything is typically passed that goes into effect for July 1st, unless the legislature declares an earlier date and the governor signs and agrees to an earlier date. Now, that is with code.
So
State
is
board rule typically does not go, well, state board rule, legislature makes some laws, I know they had a few this year that the state board is supposed to come up with rules regarding. They come up with their rules right about now, they put them out for publication, they put them out for opinion. August, September, that's when they look at them, and they typically approve them the end of August, beginning of September, whenever their meeting schedule happens to fall. Those are only temporary rules, you still have to follow them. But they are only temporary rules until the next legislative session, when either the Senate Education Committee or House Education Committee, one of the two, has to approve them. It used to be automatic, and then they started rejecting them on curriculum, when they did like health curriculums and science curriculums, and now it's a crapshoot as to whether or not they're gonna approve them. If neither of them approve, the rule goes away,
Right.
and if one of them approves, the rule goes into place.
So it's better to have like policies already in place, that way they're there.
To the extent that you
Yeah.
can, that something is impacted on July 1st, it's good to have something ready to go, or at least in process of going, but as of July 1st, you're going to be held to,
Right.
Those.
do you have a protocol, is it on your website, or are you actually following it? So you have a little bit of time.
So this type of thing should be put on an agenda for us to discuss in a meeting as to what our
You as a board
procedure
can
should be.
decide if you want to discuss it in an agenda, do you want to have a workshop where you guys sit less formally and talk about it?
right.
And what you like, what you don't like. You can look around at like all the agendas in the region, whose do you like? I think,
But delegates
There-
have to go to the front now.
right. There are a number of districts who have held, it's a training session, I've done it before, where the board comes up with, it's basically board protocols. And you come up with a formalized document, I'll have to ask April if they still have that, or Quinn, where the board will have a workshop and you decide things. Like one of the examples is, okay, what day the agenda is in draft? What's the last day for somebody to put something on it? What's the last day for all the attachments to go on? So you have a chance to read it. What is the last day that the board can ask questions to realistically expect an answer, especially from finance? Because, you know, if you got a particular check question and you ask somebody cold in a meeting, they're not gonna know what it is, but if you give them and it's those kind of protocols that have
Yeah.
existed, and there's a few districts that already have that in place.
I'm just saying, we have some of those protocols in place, I just don't know if they're written up in the policy, but
Mhm.
You
are
know,
they?
do you make it policy if it's protocols? Because it's procedure.
It's procedure, and typically it hasn't been policy because it wasn't required to be. But now that you're gonna have this new thing, you can decide what of those you're gonna put into a policy. I think Caldwell has done it formally, I'm trying to think who else locally. But, I've seen them,
Okay.
they exist. Yeah, if you get on your clerk's network and ask around, they'll.
So I have some questions, I just wanna pick your brain. As you know, we're gonna be looking at a new superintendent. So what can be done in executive session, what needs to be done in open session? Or is there, does it matter, or is it up to
In open
us?
session, you guys as a board can decide what procedures you're
Okay.
going to use. So are you going to use a headhunter, are you gonna use company X, company Y,
Okay.
company Z? Are you gonna use ISBA? What your forms are going to be, what you're going to ask them, you know, the deadlines, all that can be an open session.
Okay,
When you are reviewing initial applicants, or you're reviewing the people who apply, go back to executive session sub A, where you're talking about hiring, where the respective qualities are evaluated. And D, you're looking at records exempt from disclosure, personnel file materials and applications are exempt from
Okay.
disclosure. That all can be an executive session.
executive, okay.
When you're making those kinds, now obviously you're gonna make the decision out in open of who you're gonna hire.
Mhm.
That sometimes can get dicey, because all of a sudden you're announcing it in public before that person has knowledge, before their employer they're currently working for has knowledge, you know, so it can be a little, you know, working on the timing of that. I've had boards who come out of deliberation and everybody knows, you know, the company they're working with, or the person they're working with, a headhunter, whatever, knows where they're going, and all of a sudden they wanna make a phone call and say, if they do this in open session, are you gonna take the job? Because nothing's worse than you guys appointing somebody
Someone
and
that
they
says
say
no.
no. So it's outlining all of that, you can do all that protocol stuff in open session.
Okay,
It's the actual review, the confidential and private stuff that is done.
So
Now, that
could you,
doesn't mean you can't have a meet and greet, that would be an open, so say you've
Yeah.
got 3 finalists,
that's kinda what I was
you
thinking.
can bring them all in and they can meet the community and talk and meet with teachers. You can do it formally at a board meeting, I've also seen it done informally as truly a meet and greet. I've had districts where that's worked out great, I've also had districts where they brought them in and they decided they didn't like any of them. And the public didn't like anything, started all over
Start
again.
all over.
So you gotta be ready for anything can come at you if you do that. But
Well,
that's
we thought
another
about
way.
committees too, per zone, and that way there's certain committees and the community can, just tell us what characteristics they would want in a
What they're
superintendent, not
looking for.
necessarily
That'd be more like
them,
a survey though, wouldn't it?
but,
Mhm. Yeah.
no, I would rather do
Now, if you're
in
doing a committee,
person.
you've gotta
Hire
define
a
what their role is, because one,
Right.
it's a board subcommittee. A board subcommittee is required to follow open meeting law. So if a board subcommittee is meeting, they have to have an agenda, it has to be open.
Well, we would not be together.
No, no,
It doesn't
your
matter.
committee,
Us.
you've appointed a board committee. They have to follow all of this.
Okay. Is that for
Now,
every committee that we have set up?
That's why
every
you do the
board
policy.
committee.
That's why the
Oh,
policy
the
is that
policy,
way.
yes,
Calendar.
okay.
Now, if it's an administrative
Oh,
committee
okay.
reporting to the administration, and then the administration makes a recommendation, they don't have to follow it. If it's an administrative committee where the recommendation goes directly to the board, they do have to follow it, it's a nightmare. And clerks, I mean, I had a district years ago, and once they realized they had to do this, they had 23 different board subcommittees.
Wow.
And the clerk was like, I literally need an assistant just to help with those, and I can't do anything else. I can't do public records, I mean, that's literally all the poor woman did, was go to meetings, do minutes, do agendas, do posting. I think they're down to 3. And they slowly had to take them out, because otherwise it looks really bad to the public, where all of a sudden we went from 23 or 21
Yeah.
subcommittees to 2.
I think that's
But,
something we need to take a look at.
You can
Mhm.
certainly do a
But-
survey, what is their qualities, characteristics? If you do have a committee involved in the hiring process, there needs to be some training and education, they have to sign off on the confidentiality. They can't go out and talk to the public about what's in the applications, because all of that's confidential,
Yeah, I don't think it was more just getting input.
what they want, what they're looking for.
So that would be more like a survey, wouldn't it,
Well,
technically?
some people don't answer surveys, so then I really don't feel like it's,
And
you
they
know,
gave up their choice.
community.
Any other questions?
I was given this, and I
Yes?
was,
And like I
is-
told you, there's a few differences from that to
Yes.
this.
Is there another source for this information? Because I've looked through all of this, and it seems like some of the things that you talked about tonight are not in here specifically,
It
like,
doesn't surprise me.
like talking to the delegates and,
Well, that's brand new, so that's not in there yet.
so we could have been talking to the
No,
delegates?
oh, I'm sorry.
Okay,
No, that is just straight open meeting. I mean, it doesn't
Right.
need to be in there because you are engaging in a communication that's not on the agenda. So they figure it's covered by that.
but if it's on the agenda, we can engage with them.
I would not.
It's just
You
your
are walking
recommendation
right
that
into
we
an
don't.
open meeting violation by engaging. Because it goes this way, it goes that way, it's not
But
on the
now that
agenda.
they can't, but like our conversations could too, so like if somebody starts to talk about something that's not on the agenda, we just can stop them.
Let me ask a question. Why do you want to engage in a discussion with a member of the public?
Well, and maybe you can help with this. I feel like what my feedback is from the public is that they're finding it difficult to be heard. And so maybe getting something on the agenda, this new thing maybe will help them, with that. And so I think they want to interact.
That person can call you at any point in time, or call her, or call the administration
Mm-hmm.
at any point in time, and they can still come and say their piece. So they're being heard.
Well, like if I don't understand completely, I want to understand what they're saying. So in order to understand them fully, I feel like, not always and probably rarely would I want to ask a question, but I feel like a clarifying question about what they're talking about could be helpful for not just myself, but the rest of the board members and maybe the rest of the public that are listening. So that's my question. I don't think I want to have dialogue with every person that comes up.
Trust me, you don't.
No.
Yeah, the meeting will go on forever.
But I do think that on occasion, it would be nice to be able to say, can you tell us a little bit more about what you mean by that? Or, you know, or something really, it's not like I'm trying to say, well, I think this and you think that and argue back and forth, but just helping them to clarify their message to us. Because right now it feels like first of all, we're starting a clock at 3 minutes.
Yep.
That's really big behind them,
I
they're
know.
nervous.
That's
Somebody
what I told you,
shuts
I
their
like
fingers
writing.
in the door and distracts them, you know, then then 16 seconds before the end of it, our clerk is interrupting them and letting them know they have 16 seconds left. So,
16?
or whatever, I'm just making it
No,
up.
I was, yeah.
But I'm just saying, like,
It's a good number.
Okay, so
whatever
you-
seconds.
So you ask a question to patron A, and you don't ask a question to patron B and C. What do patron B and C think? I wasn't listened to. I wasn't as important as patron A.
but that's not an open meeting, that's not an agenda issue. I mean,
No, that's why I went separate.
Yeah.
I did a Frolic detour down to why do you want to talk to them?
right,
Why do you want to
because I
engage? 'Cause you're gonna
understood what
end up in
patron
the
B
exact
said,
same
and we
place.
understood what patron C said, but I didn't understand what patron A was saying.
But patron B and C aren't going to think that. Patron B and C are gonna be like, she thought A was more important than A.
But if we're only allowing one person to talk on a topic, then it's not really like,
You can allow more than one person to talk on a topic. It's just when it becomes, you can set rules
Uh-huh.
in your new protocol of when they are literally saying the same thing and it's becoming repetitive.
It's taking time out of
So
the
Right, and I've had chairmen say, okay, 20 of you all signed up for this. Somebody came up and said, did a beautiful 3 minutes. How many of you agree with that, basically, so you don't have to speak again, kind of thing? Are you gonna say the same thing that they just said, kind of? That's how I would phrase it, not that you
So-
agree with that.
so taking that into consideration, the fact that I want them to feel heard and understood, I also do want to hear and understand them. What's your best recommendation? Because if I go try to understand them after the meeting, then not all of the rest of the board gets to hear that.
Well, but if you haven't
Then
voted on
take it
the
back.
issue, when you come back to the next meeting, you can say, I spoke to so-and-so in follow-up, and that's totally appropriate. And this is what they shared with me.
But
And
if
you
it's
can
already
totally
an
say-
action item for the day, we don't get that opportunity. So it is, so to be clear, and I just wanna make sure, like, it's not necessarily an open meeting violation, it's just
I consider it an open meeting violation,
because of why.
and I have had judges consider it an open meeting violation.
And,
Because that subject matter was not on the agenda at the time. The transparency is you are supposed to be giving your public, that's why you're listing things out in order. You're not just randomly, it's in an order. That is telling the public when to expect something to come. So if item 12 is what you are engaging with up here, that is not transparent to the public that we are talking about item 12 subject first thing in the meeting.
so how is that different that they're talking about it versus us asking about it? Asking them to clarify what they're saying?
Because you are not engaging. They are simply stating their point. You are not deliberating or discussing with them. They are simply presenting. And it's identified as public delegation on subject matters of the agenda. They are talking, not you. I agree, we can't control which of the subject matters,
Mm-hmm.
but you can control what you are doing back.
Mm-hmm. And so, you're saying that you think that that's
I'm saying I've had judges say this.
yeah, you and some
And that
judges, but,
$2,500 fine you don't want,
right.
or the orange canvas, or the orange
You
canvas.
can keep going though, Hillary.
Let me tell you, I'm not really worried about the orange
You were in
pajamas.
jail together in orange
No,
canvas.
I won't be asking, but I'll let Hillary do it.
And there are other ways to get to the same point. Like I said, you can talk to them after, you can direct them to talk to,
And then bring it to the
or,
board.
and it
so
comes up
if-
to
And
a
then we don't
vote.
have to vote, we can
Right,
say,
that's
what
I
I'm
wanna
saying.
push it to the next meeting.
Yeah, if
Right.
it comes up
We
to a
don't
vote
have
and
to
you say,
vote
look,
on
I really didn't understand that person's point.
Mhm.
So I would
Can we
just-
take a step
yeah.
back and table this and have somebody talk to them and then bring it back? And that's totally acceptable as well.
Okay, and so that's one suggestion, like
Mhm.
how, so what other suggestions that would you have that would be within keeping of the open meeting law to help the public feel really heard? Like, I think one of them was to have like a meet, or what did you call it?
You
A
can
hearing.
have
Not
a
a hearing,
public
but like
forum.
a public
Meeting.
forum, yeah, a public
you
forum.
can have a public
Yeah.
forum. Now, in those public forums, you're typically letting them talk on any subject matter. You're giving them time limitations. You're not engaging, I mean, the administration's keeping a list of who's saying what, when, where, and following up on it. That's totally appropriate. You as an individual trustee, they've had town halls where you meet with your constituents. I know that there are a number of different protocols that have already been developed for those that you could ask somebody, ISBA, hey, just give me a protocol so it can be followed. That's to help you,
Mhm.
so that
So
it
I'm thinking
doesn't
like a
become free-for-all.
superintendent we narrow it to 3, and then we have
I mean, great.
a meet and greet, a public forum, people can ask questions, we can
well,
listen.
Or what about a
Yeah.
public forum prior to try to gather information?
That's what you were talking
Yes.
about.
Yeah.
Like
Basically
what?
wanting to know from the public.
Right.
Right, because I don't necessarily know if it's a good idea to have them meet there and help with, I just don't, I
Right.
think it's
No.
opening a can of worms.
Yeah, it could be a can of worms. I don't disagree.
And then you hire someone and then everyone's like, oh, that's not who I
That's
think.
not the person.
That's
I chose.
happened before with a coaching situation and it just taints the
Isn't it
whole
always a
community.
coaching situation too?
It is, it's amazing how
It's
important
not
those
a math
coaches are.
curriculum,
Taints
it's
the
the coaching
community in a
situation.
very bad way and I would not want to do
Yes.
that.
I agree. But understanding what the public
Once.
wants,
Correct.
there are different ways to do that, absolutely.
So surveys, public forum,
Public forum.
that kind of stuff.
Or you could, yeah, that would work. You could have an agendized item.
Wouldn't that be up to, let's say ISBA decides to do it, or one of our
Whoever.
headhunters? Yeah,
Whoever.
that's something
Yeah.
they would put together for us type thing, I would think.
Yeah, if you, say you decide to hire X headhunter,
Mhm.
they're gonna come in and tell you, okay, we've done these 3 methods, this is where the pluses and the minuses.
What do you
as a
wanna
board
do?
Decide which works for you, or you might do a combination of them. You know, you might have a public forum one night, and you might get down to, because you're gonna hear 50 different things, versus, okay, what are the top 5
Right.
things that the public wants?
Right.
And,
Well, that's the idea.
Yeah.
Narrow it down.
Yeah.
Mhm. You're not gonna appease everyone.
no, you're never gonna please everybody. And remember, you volunteered for this job.
Thank
You're never
you.
gonna please
Thank you for-
everybody.
Yes, exactly.
Yeah, wait till you get to be the point where, yeah, I volunteered to get sued, yeah. And y'all think,
What am I doing? Yeah.
So,
Are any other questions? Randy?
I don't think so.
Nope, I'm good.
All right. Thank you so
Thank you.
much.
you're welcome.
Appreciate it.
Enjoy coming up with your protocol.
Yeah, well, more work, thanks. Do
You know it's gonna be.
I have a motion to adjourn?
Make a motion to adjourn.
Do I have a second?
I'll second.
In favor?
Aye.
Michael? Aye. Hillary? This meeting is adjourned. Thank you guys for coming.